Yes. Why you are? It will be posted within 1 week. Is it memo is necessary? Once you file, remove the office of it will be posted. All right. 3rd December.
Lordship, kindly, on Monday I move out this matter, commercial appeal for hearing. The memo was not received at the pending branch.
Pardon?
Tomorrow the date was given for this thing, but memo was not received in the pending branch. I moved this memo on Monday. Kindly.
Memo was submitted or not? Then it should be listed if so.
The memo is not received. Oh. Tomorrow date was given, but the memo was not received in the pending branch.
You appear for HMT?
Memo never received by the branch. It is received here only.
No, it's
Yeah, served and unrepresented.
Ultimately, what do you want?
tomorrow the date was given.
Who has given the date?
Dishonorable court.
We don't give
Okay,
such
it was
date.
moved on Monday, but the memo is not sent to the branch.
We do not know. What is the urgency?
Today execution is listed before the trial court and they have sought. for-
Take time in the execution. We can't go on listing the matters on the basis of the listing of the execution petitions.
Kindly, Lordship.
The trial court proceedings can't govern the listing of the matters before this court.
Earlier, we have for early hearing. Kindly,
12th.
tomorrow, no.
Not possible tomorrow, 12th. Seek time in the execution proceeding. Execution proceeding dates can't govern the listing of the matters here.
Lordship, with due respect, there is no stay in the matter.
We are not going to be regulated by the dates given by the trial courts. That's right. So be clear about it.
My lord, Karnataka Village Officers Abolition Act,
Yes,
fresh matter, that I'm moving a memo for posting before this court, my lord, the writ appeal, that a fresh matter in the Karnataka Village Officers Abolition, my lord, the learned single judge has confirmed the sale deed for 1 acre 20 guntas, but the sale deed is for 1 acre. There is an urgency, my lord, the respondent may move the Tahsildar for entering the name of the respondents in the records of rights. That is the urgency, my lord.
that can be set aside. 15th of November.
Your Honor's kind permission.
My lord, tomorrow, my lord, urgency.
Not tomorrow, not possible. 15th November.
With your Honor's kind permission, your Lord.
It is always
See-
better to wait after filing the matter because it will be listed within.
Filed on 21/10, my lord.
If you seek the date by submitting memo before the court, it will be a longer date. If you wait, it might be a shorter date. Choice is yours.
With your Honor's kind permission, serial number 41, your Lordship.
November.
My lord, I have filed it on 21/10, my lord.
For 15, we will not give date, yes. 15. Every matter cannot be Mr. Counsel listed every on next day. That's the thing.
15/70,
50,
the appeal number is 15/70. my lord.
15th.
The
15th.
latter numbers also been listed before this court. That is the reason, my lord, I have moved this court.
15th. Yes.
One review petition for admission. The connected revision petitions are pending with the regional authority and are posted to 12 days before this matter.
3rd December.
Lordship, this is a contempt matter. The complainant is an ex-army officer. As per this honorable court's direction, he was supposed to get the benefit. The matter was last heard in July 2023. They came on record and they haven't filed the objections. Notice has been served. They have not been appearing. That's emergency. The benefits are not been given to the complainant.
Some date is given.
Your Lordship,
Some date is given.
no dates has been given.
It can't happen. No date, no matter goes without any date now, as far as this
No,
court is concerned.
it was last listed in July 2023, Your Lordship.
2023. All right.
And they haven't filed any objections. He's a disabled person during.
Check up whether there is a date or not. If there is a date, don't list. If there is a date, you have to file IA.
Date.
If there is no date, then 5th of December. Yes, Mr.
This is a contempt matter.
2023 contempt matter, my lord. It was last issued on June 2023. Next date is not given, my lord. The complainant is likely to retire in the next month.
22nd November. Yes, Mr.
Well, it's a fresh matter. The appellant's order of appointment as the director Kidwai has been quashed and his name has been removed from consideration of the post completely. So it may be posted as soon as the court is out. Any date that the.
What is the urgency?
Urgency is that someone else is appointed, my lord. So he is out of the post and his name has been not considered. They said appoint anyone else but the appellant.
December. 9th December.
It's a fresh matter, my lord. This is matter of contempt, my lord. It was filed in September and it has not been discussed till now.
10th December.
It's fresh matters, my lords, contempt matters.
11th December.
It's a fresh contempt matter.
12th December. Why or there is no system of filing and getting the listed? These memos are, yes,
By petition is the Union of India Ministry of Defence, Madam. To its center, there is threat of disconnection of amenities, therefore I request for a short heading.
this connection of,
Discussion of disruption or disconnection of amenities,
by,
The center wherein Agniveers are trained, there is a notice from the Pollution Control Board that there will be disconnection of amenities, Some from.
12th.
Filed the arbitration immediately after lapse of 8 years. I filed my objections to the IMS that we heard on the IA. They've got an interim order of stay. The appellant has filed an arbitration with MFA, my lord, after lapse of 8 years. They've got an interim order of stay. I have filed my objections to the IMS. Maybe heard on the IA.
So
Next week.
it must be, date must be,
Date.
your file IA,
Yeah, I filed objections to their IMS.
but then I,
It's not been fixed.
date is not fixed. Let it go to 12th December, 13th December.
If I may mention, my lords, item number, serial number 55 in list 1, my lords, there is some inconvenience if you may grant us a short accommodation and for the petitioner. 55.
13th December.
Pending public interest litigation.
With,
my lord.
with the
At
honors,
the request of learned petitioner, stand over to 13th December.
Oh, bless.
47, my lord.
with your honors kind permission, serial number 41, lordships.
Pending public interest litigation, my lord. The urgency is that, my lord, there is difficulty to breathe, my lord.
You admit online persons only after this is visible.
Pending public interest litigation, my lord. The urgency is that, my lord, the petitioners are finding difficult to breathe, my lord. A public park has been illegally occupied and rearing of pigs is taken place, my lord. The extreme urgency, my lord. It is, they are living in most unhygienic conditions, my lord. It is difficulty to breathe, my lord. That is the.
Still be listed. Remove the office officer and it will be listed.
My lord, it is already, it is a pending letter.
Then file IA.
I have filed, my lord.
IA is filed.
Yes, my lord. Extreme urgency. They are finding difficult to breathe, my lord. That is-
16th December. Yes.
Still number 47, my lord.
Still number
47, my lord.
47. Yes, 47.
Some accommodation I request because I have not well today.
17th December, as requested by learned advocate for the appellant.
Serial number 41, my lords, for the
Still number
petitioner. Serial number 41, my lords, for the
40.
petitioner. Seek for
I appear for the
accommodation.
respondent in this case.
The matter is pending before the Supreme Court and there's a stay and the mediation is going on, my lords.
At the request.
The matter is coming up on November 26th, my lord. Kindly have this matter after that because
18th December, yes.
Second week of December, my lord. Second week of December.
18th December.
you all know, kindly have it first week, your lordships, please, because the custody of the children are involved and the matter is likely to be over on the 26th.
Additional documents, some documents we are yet to receive from the other side for respondent.
Pardon?
Ticket number 78, my lord.
17th.
In the writ appeal, we are supposed to file the objections, my lord. On the last date of hearing, we have been served with the application, my lord. Additional documents we are supposed to receive from the other side, my lord. They've said they'll give it in 2-3 days, my lords. 1 week time may be given.
At the request of learned advocate for the petitioner, appellant.
Respondent, my lord.
for the respondent. Stand over to 18th December.
Serial number 48, my lord.
14,
48
48,
for the respondent, my lord.
yes.
2 weeks accommodation file.
Petitioner has no objection.
To file the reply for the respondent accusing.
That's right, will grant time, but petitioner has no objection.
We'll just will inform.
First inform, then mention. After taking consent, you will grant.
Serial number 44, your lordship.
44,
44, this is the PAL regarding preservation of peace by order, in order dated September, your lordship. Your lordship had directed, the RN is here to do the process of
that
inspection.
is the tree matter.
Yes, my lord, telling of the.
There are people standing in the line now.
With a memo where they have
See,
done the inspection and have given fresh reasons. We require 1 week's time to go through the memo they have filed, your lordship, it may be had any time.
25th November.
Interim order may be extended, your lordship.
Vote in.
Interim order on IA number 3, which is a pending IA. your lordship.
25th, stand over to 25th of November. Interim order earlier granted in IA number 3 of 24
24.
shall continue to operate till the next. Yes, anything?
No, ma'am, serial number 1.
Yes.
Any mention through EC, sir? Kind permission. This contempt matters, serial number 1, Ajay JN.
Notice returnable on 13th.
Serial number 2. To Venkatesh.
Where are the directions in 42151?
My lord, at page number, page number
Page number
22,
22.
para number 14. There was an earlier writ petition, my lord.
27, Mr. Not
22,
huh? 27.
para, page number 22, page number 22, para 14. The respondent are directed to adhere to the
They are
directive
seeking compensation.
compensation.
Notice 13th December.
Date, ma'am. December.
Serial number 3. With the Kavita Damodaran.
Direction, my lord, to the surveyor, the BBMP, to conduct a survey in relation to a road and to submit a report to the AGA. The relevant order is at in page 80. Page 83 is the specific direction to the AGA.
Page
83. Para 1.3.1. The learned AGA, my lord, page 83. The learned AGA through 1.3.1 I'm reading. The learned AGA through Deputy Commissioner in ADLR to carry out a survey of land in survey number so-and-so of so-and-so village to demarcate the 40-feet road as shown in CDP 95 and file a report indicating whether the road has been formed as in existence. If not, what is situated in the said location with details thereof. But in fact, at page 96, in one of the subsequent hearings, a submission is made on behalf of the learned AGA that a report, the survey has been carried out and the report is being prepared at page 96, para 2. The submission was that by 19th January, page 96, madam. December 2023, the learned AGA makes a submission that a survey has been carried out, which has been confirmed by the other councils. He submits that a report is being complied and would be filed given 2 weeks' time. His submission is placed on record. The report is to be filed on or before 19th January. Not done till date. Not done till date. Not done. The report has not been filed. Survey has been carried out is what they say. It has been carried out jointly. But
Then
report
you-
has not been filed.
You are alleging contempt of which order?
I'm alleging contempt of the order at page 80 dated 9th October 2023.
So that requires conducting of survey.
Has been carried out. That requires conducting of survey. Survey has been carried out and the report is being prepared is what is submitted at page 96. They are still not complying with that order of submitting the report. Survey has been carried out. There is no difficulty about it.
Report has to be submitted before the learned single judge, my lord, as per the records. Survey has been conducted here. An interim order, my lord, the
But if
learned
the
single
report
judge is
is-
seized of the matter.
If the report is submitted,
certain
nothing will survive.
status, my lord.
Interim order, yes, but then why you are not submitting it?
That's, I will ascertain, my lord. I'll take notice and I'll take notice, my lord. I'll ascertain the fact, my lord. Survey has been conducted here, my lord.
No notice. You
Regarding the submission of the report, my lord.
You ascertain, this is the only thing.
The only thing, my lord, survey has been conducted. Whether report has been filed before the learned single judge or not, that I will
What
ascertain.
prevents you from submitting the report?
I'll ascertain that fact, my lord, whether the report has been submitted or not. Survey has been carried out.
Day after,
Please, my lord.
learned
Grateful.
additional government advocate, Mr. Harish. Course of the hearing of the present contempt petition, short time to ascertain as to what is preventing
Please.
the authorities from submitting the survey report. From when the survey is already undertaken and concluded as reflected from the statement of learned advocate general.
Please.
Tender also. Not issuing notice, but you ascertain.
Please, I'll ascertain.
Great.
Yes, number 4, Mr. Kumar JC.
Year 1999, my lord, the Committee for Regularization of Unauthorized Cultivation is regularized the land of 1 acre of land of the complaint, my lord. Again, thereafter, my lord, the complaint has paid the kimmat to the government. Subsequently, my lord, some order is passed against the complaint herein and same is challenged before the Deputy Commissioner. Deputy Commissioner, my lord, by order dated, my lord, 21/9/2022, my lord, it is remanded the matter, my lord, for reconsideration. And matter is pending before the authorities, my lord. In the meantime, the very Deputy Commissioner has granted including this land to the present respondent. And as against the said order, my lord, the kindly see the Annex A, my lord, the complaint has filed the appeal before the Karnataka Appellate Tribunal as per Annex A. In the said order, my lord, the Karnataka Appellate Tribunal has granted interim order of stay of the grant made in favor of the respondent, one, my lord. My lord, subsequently, as per Annex A, my lord, E, page number 29 is communicated the order passed by the Karnataka Appellate Tribunal to the respondent number 1. Right, it is duly served. In spite of that, Your Honor, kindly Annex H, my lord, they are come to the land, Your Honor, they are trying to interfere and dispose the complaint land, my lord. Therefore, my lord, we file this.
Which order you are?
My lord, kindly see the page number, direction, my lord, 19, my lord.
What is the direction?
Last paragraph. The impugned order dated 21/9/2022 passed by the respondent number 1 in case number LNDS CR 1999-2007 in respect of the land measuring 1 acre out of survey number 28 of Agra village, Kengiri Obli, Bengaluru South Tala, Bengaluru East State till in a state of hearing. It is communicated to the respondent number 1, my lord, as per Annex. E, my lord, page number 22.
Interim order.
Interim order.
Go before the tribunal.
My lord, in spite of the interim order, my lord, they are kindly say pay. I have produced
Admittedly, the order which is brought under the contempt jurisdiction of this court, dated
page number
18/7/23,
19.
is an interim order whereby
Last paragraph. Page number 19. The impugned order dated 21/9.
dated 21/9/22, passed by respondent number 1 in respect to the land in question. Is stayed by the tribunal till the next date. By very nature of the order, which is interim and does not decide the rights of the parties finally, the jurisdiction of the court under the Contempt of Courts Act 1971 is not liable to be exercised. The proceedings are pending at large before the Karnataka Appellate Tribunal. The petitioner may work out his rights and remedies including in respect of the grievance about the alleged breach of the order before the tribunal in the pending proceedings. Without expressing any opinion on merits, the contempt proceedings are disposed of as not entertained on the aforesaid ground alone. Yes, next.
This is number 5.
My lord,
Should K.
direction
Prasanna
fully
Shetty.
disposed at Karnataka Appellate Tribunal.
It will be open for the petitioner to request the tribunal for early disposal of the main proceeding. At this stage, learned advocate Mr. So-and-so requests that the tribunal may be directed to dispose of the matter at the earliest. Full stop. The request is reasonable. The tribunal is, it is open for the petitioner complainant to request the tribunal for expeditious disposal of the case.
5, Mr. K. Prasanna Shetty.
I appear for the complaint.
Notice returnable on this. 5 and 6 both. Notice returnable on December 11.
Please.
So what is the problem?
Please, my lord.
What is the issue?
Lord, that is, they have taken over the land by notification in pursuance of the BBMP.
Who?
That is, BBMP has taken over the land of the respondent belong to 10 and 11. That is the owners of the land for establishment of waste.
Oh, then 10 and 11 may come as a petitioner. Why you are here?
Please, my lord.
If the land of the respondent 10 and 11 is taken away for some purpose
Yes, my
by
lord.
the BBMC, let them come.
Yes.
No, what I am saying is, my lord, here, the transferable rights which were given it to the 10 and 11, they sold it to 8 and 9. But they want to utilize other than the jurisdiction of that local area that is in Bangalore.
They will inquire. Why you
Please,
are,
my lord.
why you are worrying?
No, they are not inquiring. They are hand in glove with these respondents 8 to 11. My lord, kindly go to page number 34. If it is converted into Bangalore like this, we are worrying only thing. They are giving away the land, agricultural land or any other land, which is low value, somewhere outside the Bangalore. They want to utilize in Bangalore like TDR, that is FAR area, to be utilized in Bangalore. That amounts to several crores of rupees. Well, now they want to convert the Bangalore into concrete jungle. As of now, it is already. Now, kindly go to, I have calculated, page number 34. Simple as it is, my lord, this is very, very simple. Kindly, 40 acres they have given. My lord, page number 34. I have calculated how much it was and all.
Page number 34.
34 of the petition, my lord.
What is this?
My lord, kindly see, 40 acres land was given to the BBMP. 40 acres at that time when it was acquired, it is only 14 lakhs. Well, 14 lakhs into 40 acres, 5 crores, 72 lakhs, 60,000. That should be given it 1.5 time as a TDR. That is 1.5 time in square feet. Well, that is calculated into 40 acres converted into square feet, 17 lakhs, 41,680. That is 1.5 time we have to give it. That is the square feet of 40 acres. That is 1.5 time has to be given TDR. That is 1.5 time is calculated. Well, kindly see, 26 lakhs, 12,250 square feet. Well, if it is used in anywhere in Bangalore, not less than 15,000 rupees square feet. Well, that converted up to coming around 3 billion it comes to. For 40 acres, it comes to 3 billion. If it is only 15,000 rupees calculated. If it is a prime area, use it in prime areas like MG Road and that should be utilized within that local limits, local area. If present guidance value is taken, my lord, it goes up to 7 billion. But page 120.
Where is 3113?
Please, my lord.
Government order 3113 at which page?
Yes, my lord. That is at page number 90. Page number 90. 3 conditions are there here. That is a translated English version, my lord.
Page number 90.
90. Last three lines, my lord, 40 acres, 9 guntas of Kodiala Karinahalli village, Ramnagara Taluk, Ramnagara district for establishment of waste treatment plant. That is the conditions below. They should utilize within 25 kilometers radius.
What is BMI CAPA?
That is the local authority, Bangalore, Mysore Infrastructure Corridor Area Planning Authority. These lands come within the jurisdiction of that area.
So you're aggrieved by page 90.
Please, my lord.
You are aggrieved by page 90.
No,
No.
I couldn't get, my lord. I'm sorry, I couldn't get it.
You're aggrieved by page 90 circular.
Yes, my lord, agreed in the sense, I am not questioning this. I am only saying that utilize a DRC, that is a development rights certificates are issued, that utilization of DRCs is not yet taken place.
Not challenging this.
I am not challenging this. I am,
See your first line of your list of events.
please, my lord.
You are not challenging page 90.
No, I am not challenging this order. I am not seeking for quashing
Go
of
to-
this order.
Go to first page of your petition. The petition challenges the government order dated 3/1/13 issued by R2 in violation of TDR.
Lord, in the kindly go to prayers, my lord. I am not challenging that.
We do not know.
No, kindly go to prayers. I don't know where, which paragraph, my lord. I only said petition has been fighting corruption, illegal activities. That's all I said.
So synopsis.
Kindly go to prayers, my lord. I'll.
Prayers, yes.
Yes, my lord. I'll. Lord, at page number 42.
42. We are already on 42.
Yes,
We are
my lord.
already on 42.
So there I am not seeking for quashing of anything. I am only call for the records, then issue mandamus to.
Prayer B.
Yes, my lord, that is a concession given there.
Prayer B.
Concession, please, my lord.
Prayer B.
Yes, my lord, prayer B, I am not seeking for quashing.
Read it.
Yes, my lord, mandamus to the first respondent, withdraw, withhold the concession given to the fourth respondent. As one-time measure, the land in question which has taken passed in cabinet, also conditions imposed from the state government in the interest of equity and justice.
So this prayer can be granted without challenging page 90? Whether this prayer can be granted without challenging the government order dated 3/1/13?
Not those conditions which are given, because now in view of this,
We want yes or?
they are extending, my lord, what I am saying, I am not, I don't want it to be quashed, my lord, let there be given it. But I am only saying that the DRCs which are issued now, utilization of DRCs cannot be made even in violation of the procedures. That is at page number 128. Kindly go to 129.
Challenge page 90 then.
Please, my lord.
You have to challenge page 90 order.
Lord, if that is the case, I'll amend the prayer, man. I'll amend the prayer.
Whatever you want to do. It is your, we are only pointing out that prayer B cannot be granted in wake of page 90. Whatever you want to do next, you do. Either you withdraw the petition, whatever you do, you drop prayer B, whatever.
Kindly 2 days, my lord, I'll see that whether to take out that prayer or to amend the petition.
Tomorrow? Day after
My
tomorrow?
lord, day after tomorrow, at
Yeah.
least I'll ask.
Learned advocate.
My lord, how the petition, I'm sorry, my lord, I'm submitting without my lord's permission, but I'm seeking.
We
my
have
lord,
put some queries and he is wanting to amend. We do not know what will be followed.
My lord, how he describes
I-
himself,
Stick-
my lord, how he describes himself. Paragraph, my lord, 1, particulars of the petitioner is nothing for pure
My
publicity.
lord, kindly
my lord.
consider the interest of the public. My lord, I am not, we have no interest at all, personal interest. Kindly consider somewhere given in the land and they want to invest here by crores of rupees, giving a lakhs of rupees and coming here and making billions of rupees and to spoil the Bangalore also, my lord. Kindly, this is very serious matter. I am not saying that we have, maybe some, my lord, this is a technical error, sir. My lord, I will consult with my, other colleagues also. My lord, this is the thing. Kindly consider the interest of the case, my lord. I am not saying.
Whatever you want to do, you can do.
Your lordship kind enough to consider these things
We are not-
because,
We are not in advisory jurisdiction. We don't advise anybody.
yes, my lord, but this is the thing. My kindly, what I am saying is, my lord, giving a land somewhere, my lord, this is a common sense, my lord. If I give a land, if I have a land around 300 kilometers away for around 20 lakhs or 30 lakhs, coming here and utilizing the same in a square feet, my lord, your lordship knows that in a city, not less than 20 to 30,000 rupees per square feet in Bangalore.
It might be a common sense for you. We have a legal sense.
No, no, no. What I am
One
saying
said
is,
it
my lord,
common sense and we
No,
have
no,
to
no.
understand.
no, my lord, even legally, what I am saying is, my lord, I am sorry. If your lordship taken me as a, in that sense, I am very, very
That's
sorry.
making it.
My lord,
You are suggesting that only.
no, 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 we are
We
not
are not
sugge-
understanding common sense.
No, my lord,
We
even,
understand legal sense only.
no, no, even in legally, my lords,
Common sense. Court is only legal sense. So be clear about it.
my lord,
Not
legal
making any
sense only. What I am saying is legally it is around 20 to 30,000.
What do you want to do now? You want to proceed with the argument, then we'll deal with the matter. If you want to time, you seek time.
Yes, my
Whatever.
lord, I'll,
Learned advocate, Mr. So-and-so, 6 times, 10 to
Monday, my lord, at least,
11th as requested.
please.
Seal number 8. To J.R. Mohan. Query for petition.
My lord, this
Well,
again is a case where he's seeking for consideration of his representation. My lord, on 22nd October 2024.
Such petitions are disposed of when?
Yes, my lord. That and serial number 9.
Even, yes, ma'am. Serial number 8 and 9 also.
Yeah.
Just to consider my representation, that's all.
Then withdraw it. Since we passed one met such order in matter, you can't go on filing such frivolous
No, ma'am,
public interest.
This
petition.
petition had already been filed long ago, ma'am. This petition was filed in the month of January. Today it has. My limited prayer is to consider my representation, that's all, ma'am.
You have invited battery of advocates. Why you are appearing? In advance you're appearing in advance. No, notice is issued. Notice is issued. Where is not?
Notice is not yet issued. This is fresh matter. Notice is not yet issued.
Or learned advocate Mr. So-and-so for the petition. And learned additional government advocate Srimati Nilofar Akbar for this number 1. State. And learned advocate Miss for respondent 2, who both appeared upon service of the copy of the petition in advance. The petition is presented as public interest petition. What the petitioner stated is that in the year 2018, 3 new taluka headquarters in the district of Bidar, namely Kamlanagar Taluka, Ulasura Taluka, and Chitta Kuppa Taluka, came to be formed by the state government. They are under the Kalyan Karnataka region. It is the case that during the period from 2019 to 2023, the government has sanctioned large amount of aid for development of the region. However, out of the allocated funds, as per the say of the petitioner, not a single developmental work is taken up in the new talukas. It is averred that administrative building is not available for such works. And even the hospitals are not set up, which creates for the people of the region hardship and inconvenience. It is the case that the petitioner has made representations dated 5/9/2023, requesting the competent authorities to take up the developmental works in these PHES, these talukas. Paragraph. Petitioner has stated that in response to his representation, respondent 2, the director of respondent 2 board, respondent 2 Kalyan Karnataka Regional Development Board, has addressed a communication dated 12/9/23, requiring the Deputy Commissioner of Bidar, as respondent 2, to take up the developmental works in the newly formed taluka headquarters. Despite the correspondence between the authorities, despite the correspondence amongst the authorities, respondents have not taken any steps in this regard, alleges the petitioner, full stop. As all the developmental works have remained on paper, and according to the say of the petitioner, any concrete step is not taken, this petition is filed. Paragraph. What is prayed by the petitioner is to direct the authorities to carry out the developmental works by setting up government offices, etc. in the new taluka headquarters. Full stop. The grievance of the petitioner is to be taken care of by the competent authorities, who will have the necessary data and the assessment of the requirement. The public interest petition cannot be entertained. Paragraph. In view of above, no relief could be granted to the petitioner except permitting the petitioner to pursue his representation dated 5/9/2023, which are produced at annexure, which are produced along with the petition. The authorities, the competent authorities, the respondents may consider the same in accordance with law, expeditiously, with the above limited observation. Paragraph. The present petition is not entertained and stand disposed.
My lord, if I may. Serial number 54, my lord.
Serial
The
number?
very same petition. There's another PI.
119, serial number 9.
Nine.
Number 9,
Four.
very for petitioners.
54. What is it? 50?
Same petition, my lord. There's another PI.
It's PIL. Same.
Same, very same.
My lord, in this we have filed a memo taking some initiatives, my lord.
Heard, same heard, except not upon advance scope. You set
My
up
lord,
the-
I filed a memo that is,
You set up the hospital.
my lord, we have taken some initiatives, my lord. We have to take it to its logical end. We have written to the government.
Where is that?
My lord,
You not filed anything.
I have filed it, my lord, and I had undertaken to file the English translation also on 19/7/2024.
7/2020. नहीं है मैं not. 9/1/24. No,
19/7, my lord, memo,
memo.
yes.
Doesn't appear to be there. The grievance of the heard must end. The grievance of the petitioner in this public interest petition
Copy.
is that so the new talukas named Kamla Nagar, Ulasura and Chittaguga are formed in the Bidar district as back as in the year 2017. The talukas are without the facility of hospitals. As such, hospitals are not set up by the government at the taluka levels in the newly formed talukas. It is prayed by the petitioner to require the respondents to upgrade the existing government hospitals in the newly formed taluka and to have 100 bed facility. The petitioner has made a representation dated 8/11/23 in this regard. Which was disposed of last? No, previous. 8. Full stop. It may be noted that writ petition number 1030. It may be noted that the public interest petition number 1030 of 2024 was filed, which was more or less on the similar lines and with the same petitioner prayed for speeding up the developmental work, including hospital, in the newly formed taluka of the Bidar district. The said writ petition number 1030 of 2024 has been disposed of. By the court today, requiring the petitioner, permitting the petitioner to pursue the representation and requiring the respondent authorities to consider the same expeditiously. Full stop. It is provided that when the authorities considers the representation of petitioner as directed in the said petition, the aspect of upgradation of hospitals in 3 newly formed taluka shall also be actively looked into. Full stop. Furthermore, paragraph from the record of the present petition, it transpires that a communication dated 5/12/2023 has already been addressed by the Hyderabad Karnataka Region Development Board to the Deputy Commissioner of the Bidar district, along with other districts, for upgradation of the government hospitals in all newly formed talukas of Kalyan, Karnataka region into taluka level general hospitals and construction of 100 bed hospital with the aid of Karnataka. What is KKRDB? Kalyan Karnataka Regional Development Board. As also to establish the science centers, research centers in such newly formed taluka to ensure the development and providing for infrastructural facilities in these talukas. Full stop. It is expected that the proposal which is already forwarded and under consideration by the competent authorities shall be taken to its ultimate end. With due expeditions. The present public interest petitions accordingly disposed.
Obligation.
Then 9.
9 is also.
9 may also
10.
be disposed of on the same lines. Ma'am. This
My lord,
writ
this
petition,
pertains to
serial number 9 may
residential
lord.
quarters.
This writ petition may also be disposed of on the same lines.
Does it? The same or same heard same,
Yes, my lord.
like first matter.
Yes, ma'am.
10,
That's all. That's all.
that's all heard. What is this?
This is regarding providing basic amenities to the Aurad Hospital quarters, my lord. In the, there is a general hospital in Aurad Taluka. By the side of that hospital, my lord, there is a quarters. In that quarter, several hundred officials of the health department are living. However, my lord, this quarter does not have even the basic facilities such as water, street light, drainage system.
So similar to it, but just look at the prayers.
Much obliged, my lord.
Obligement.
Seal number 10, Mr. Prashant Matapati.
Lord, for the petitioner, my lord. Lord's annexure A, my lords, is the order passed by the deputy commissioner. Wherein, my lords, he permitted to build to the, my lords, solid waste disposal unit, which is contrary to his own order, my lords, as per annexure B.
So what is the order at annexure?
My lords, annexure A, my lords, wherein, my lords, the deputy commissioner. Lords,
Let us see which page.
lords, which is at, my lord,
Where is that order?
translation copy 47, my lord.
Page 47.
Please, my lord.
So you are challenging this order.
Please, challenging the annexure A, my lord.
So this is for on the contrary construction of the solid waste disposal unit.
Please, my lord.
So what is the grievance about?
Grievance, my lords, annexure B for a moment, my lord. Annexure B. Translation copy, my lords, page number 57.
Hmm.
My lords, last two para, my lords, are permitted to read. My lords, where, my lords, we filed an objection, my lords, earlier in the year 2020, which was considered by the deputy commissioner and, my lords, rejected their proposal. Now, my lords, once again, my lords, he permitted to, my lords, build the disposal unit. Considering the, my lords, all grievance of the, my lords, the petitioners. Page 58, my lord. May I read, my lord?
So B is first in point of time or A is in first of time?
B is the first, my lord, first order.
B is in.
Please, my lord, sir. That is,
Annexure is consequential.
please, my lord. It is, B is, my lord, in respect of 654 survey number. But within 500 meters, my lord, 667, my lord, he,
654.
54.
And this one is
667, my lord, sir. The distance between 654 and 667, only 500 meters, my lord.
500 meters.
Please, my lord.
Then either both are wrong or both are right. What we can do? It is their own consideration where to set up the plan.
And we bring it to the notice of the, my lord, sir, defend number, respond number 2. My lord, so where we have orally, my lord, sir, replied that earlier DC was changed. After considering our, my lord's objection, what's even, what is the photos copy also, my lord? Page 95, my lord. During the rainy season, my lords, the polluted water steps into the lake, my lords, if the same is permitted. And in RI report, my lord, there is 11,000 my lords, cattle in the, my lord, said village.
Heard learned advocate Mr. So-and-so for the petitioner and learned additional government advocate Srimati Nilofer upon service of copy of the petition in advance. Who appeared upon service of in advance. order dated 4/7/2022. Came to be passed by the Deputy Commissioner, Belagavi, disposable to hearing, whereby the said competent authority allotted land revenue survey number 667 at measuring 85 acres and 13 guthas situated at Kabbur village of Chikkodia Taluka, Belagavi district. To be utilized to the extent of 5 acres, for 5 acres.
5 acres.
To be utilized to the extent of 5 acres out of the total for construction of solid waste disposal unit. In accordance with rule 90, to be done in accordance with rule 97 and 4 of Karnataka land grant rules 1966, and as per rule 20 into bracket 1 into bracket small c of Karnataka land grant rules 1969. At a price fixed and on the conditions mentioned in the order. The petitioner claiming to be the petitioners claiming to be public interest, public spirited persons and the residents of the villages have sought to call in question the aforesaid order of allotting the land for solid waste disposal unit. One of the ground, the main blank of challenge appears to be that, as submitted by learned advocate for the petitioner. Then that, as submitted by learned that earlier, revenue survey number 654 of the very village Kabbur was considered for allotment of for allotment for the purpose of solid waste management unit, and the proposal was forwarded on 10/12/2020. Copy of the said proposal is produced on record. Full stop. The said proposal was not carried forward and was rejected and came to be rejected by the competent authority. It was recorded in the said order dated 10/12/2020, dropping the proposal, inter-alia, that the Kabbur village, where the place of the Kabbur village where solid waste unit was proposed to be constructed was not suitable. It was stated that there is a Mahalakshmi temple situated in the place. It was stated that there are lakes and wells adjoining the place on which the villagers of the Mira Marahatti, M-I-R-A-M-A, R-H-A-T-T-I, Mira Marahatti and Lakshmi Kodi villages were dependent. It was also recorded that the stench smell would come out due to accumulation of the waste. And since the site was too near to the habitat, lakes and the temple, that particular site was not suitable. And full stop. Therefore, the order rejecting the proposal mentioned that it was in the interest of public health that the proposal was liable to be rejected. Another land was to be identified for the purpose. It is the case that the alternative site identified, which is reference number 667 as above, is in the same village and nearby the earlier site. Therefore, there is no justification in selecting reference number 667 for establishment of the solid waste management unit. Full stop. The argument could hardly would hardly derive any merit, inasmuch as while rejecting the earlier proposal as per order dated 10/12/2020 referred to above, relevant considerations had gone into the decision of the authority which rejected the proposal. Full stop. The new site is selected. Full stop. These decisions are in the realm of executive wisdom. Full stop. When they are based on germane considerations, it is not for the court to substitute its opinion. Full stop. Which site is to be selected for setting up a plant, such as waste management unit, is entirely for the authorities to decide. Full stop. Unless the decision in this regard taken by the executive authority is palpably, is manifestly arbitrary, perverse, or against any statutory provision, the court would be disinclined to reverse it or substitute with another view. Full stop. There is an added aspect. There is an additional aspect which would also disentitle, which would finally disentitle the petitioner from seeking any relief. Full stop. From the order from the impugned order, it could be seen that on 28/9/2022, public notice was issued as per section 68(1) of the Karnataka Land Revenue Act. Under the said notice, public at large was invited to submit objections within stipulated time of 30 days from the date of publication. Tahsildar Chikkodi had submitted a report that no objections were received during the said period from anybody. The proposal was accordingly submitted to government as per letter dated 12/12/2013 and 13/10/2023 and 13/12/2023. Pursuant to which the notification was issued selecting the site for setting up of the solid waste management unit as reflected in order dated 4/7/2024. Not only the relevant considerations weighed with the authority, the objections were invited as per the statutory procedure and the report and from the general public, but no objections were received. The Tehsildar submitted the report accordingly, and finally the notification came to be issued. Full stop. Setting up of solid waste management plant is itself a public purpose and will serve public interest by treating solid waste management. Full stop. No case is made out, paragraph, for granting any relief to the petitioner. The petition is dismissed.
Still number 11.
.1 has become infructuous.
Yes.
Because the government has filed a memo stating that the lands have been granted and
Correct.
the payer is satisfied.
To those eligible persons, the land is granted.
Yes, my lord, 114 beneficiaries,
14 win
114.
and 94 were rejected. 94 or 92.
In fact, I filed,
They can again make an application, my lord, on technical grounds it was.
I filed a memo, my lord.
It is
which has-
rejected on technical ground or on the ground of eligibility.
Eligibility,
Eligibility.
yes.
Please.
You will have to challenge that order,
Correct.
not this order. Not in these.
Why
And
should
the
we?
grant certificates have also been issued, my lord.
Pardon?
Grant certificates, 214 people have been issued.
114.
114, my lord, please.
We
My
are
lord,
for
each
petition.
gets 2 acres, my lord.
In writ petition 13081, I appear for the respondent, my lord. In 1097, which is connected, I appear for the petitioner. In 13081, the matter it is a fact, my lord, 114 grant certificates have been issued. In fact, I have filed a memo with one of the grant certificates, my lord, just as a,
So you are for petitioner.
not in 13081, my lord. In the connected writ petition, I'm for the petitioner. In 13081, I'm for the respondent,
For which respondent?
7th respondent, my lord.
7th respondent.
Please.
What about the other matters? Same? All are same?
Not only 1097, writ petition number 1097, that is challenging the order of the Karnataka Appellate Tribunal, where in respect of some portion of that land, that, my lord, was actually being heard by the learned single judge. Since this matter had been filed as a public interest litigation, this was also taken. That matter alone would have to be heard because it challenges the order of the Appellate Tribunal. So that would have to be heard insofar as the merits of that are concerned, my lord. The other matter, both writ petition 13081 and the other matter are in respect of the beneficiaries. So those two are separate. In respect of writ petition number 1097, that would be a separate issue which will have to be looked at separately.
Will have to be heard by learned single judge.
Please, my lord, it may be, please, it may be.
Earlier itself, my lord, that it would be dealing then posted before. the
Please, my
present
lord, that
single
may be
judge.
done.
Because nothing PIL is there, my lord. It
Yes,
an
that is a fact.
individual order from
But
KSA
one
to-
clarification insofar as 1097 is concerned. Towards the claim of the petitioners in the other public interest litigation is in respect of 370 acres. But then, lords, even in 1097,
But,
lords, in 1097, about 67 acres has been granted to the grantees. About 23%, lords, 67 acres has been granted. Now, the claim of the petitioners in the public interest litigation is that the entire 350 acres have to be granted to the very same community and it should not be granted to anybody else. Nevertheless, lords, about 67 acres has been granted to other communities who are in possession of that land, lords, and who have been conferred grant in the year 2003 on an application made in the year 1991 itself.
these are the submissions to be made before learning single.
Please, my lord, that
We
may
can
be-
make it there, but at the same time, lords, the only clarification I am bringing to lordships is that the 350 acres which the public interest litigants are claiming also includes the 67 acres. That's the reason, lords, it was tagged along.
Even then, these two petitions will not overlap.
It may be so in view of the filing of the memo now, where lords excluding the 67 granted to,
But this 1097 came to be tagged with these matter by some judicial order.
by way of a,
By virtue of a judicial order.
Yes, my lord.
on the submissions made in the other petitions, lords, this was. It was only for the reason.
In fact, they made a submission, my lord, before the.
Lords,
learned single
the,
Similar matter is pending before the division bench, therefore it was tagged, my lord, but
there is overlapping. Lords, the reason is that in 1097, lords, may I announce? The extent of 67 acres, lords, which is included in 1097, lords, that is overlapping in the claim made by the,
Then
in
we'll
the
permit
public
you-
interest. That's all, lords. I want to clarify.
Will permit you to raise that aspect also before learning single.
We can do that.
Not touch the
merits, merits.
disposal of the other.
Other writ petitions, it may be
It may
disposed.
not, that submission will not prevent in any way the disposal of the other.
That will not, lords, that will not. But then nevertheless, lords, if it can be clarified that, lords, all the contentions so far as the grantees of those 23% are concerned, if we are kept open with all the contentions, we will urge before the learned single judge.
My lord, may I submit, my lord? Both the public interest litigations are only in respect of who is being granted. Insofar as the identification of the beneficiary, an entire exercise was carried out. And finally, 114 persons were identified and the grant certificates have been issued to them, my lord. The other writ petition, that is writ petition number 1097, that is in respect of one portion of this land, which was previously granted to certain other persons. And that, I'm sorry, my lord,
Petitioner in 1097.
in 1097, I appear for the petitioner. Ma-
So your land is affected.
I'm sorry, my lord.
Your land is taken away.
My lord, what happened in writ petition
Then what
1097?
is, why you are challenging, what is your locus?
In writ petition 1097, my lord. My lord, what happened was that those petitions, this entire area of land, which is 350 acres, was reserved in 1962 for the Hakipiki community. This land having been reserved for them, subsequently some portions of the land was granted to some other persons. At that point of time, the petitioners in writ petition 1097 had approached the appellate tribunal, challenging those, I'm sorry, my lord, and that grant that had been made was cancelled. The cancellation was challenged before the appellate tribunal. The petitioners in 1097 filed an impleading application in the matter before the appellate tribunal and sought to be heard. That the appellate tribunal finally allowed that writ petition, allowed the appeal. That appeal has been challenged by me in the writ petition, my lord. Because I am one of the beneficiaries insofar as there are several other petitioners who are beneficiaries. In fact, my lord, when when writ petition 1097 was pending, several orders came to be passed. So effectively, my lord, that challenges the order of the appellate tribunal. So that, insofar as that is concerned, my lord, it might have to be heard. Several orders came to be passed. In fact, my lord, an order also came to be passed by the learned single judge, saying that even though
there is absolutely nothing to show, my lord, that the land was earmarked for any particular community. The only order that was passed was, it is delinked from the forest area, handed over to the revenue department. That is all, my lord.
Annexure D.
Except, that is annexure D, my lord. Except that there is nothing to show that they have vested right in that land.
in fact, my lord, that land was forest land.
That
It
is
came to
what
be
has been
denotified.
decided by the appellate tribunal, my lord. They have no right over the land. Annexure D will clinch the issue, my lord.
An order came to be passed, my lord, in writ petition 1097.
Page 44 of the
40. Typed copy 44.
No, this
41.
three, we are on 1097.
Please, my lord.
Page
So
41.
ultimately, the learned single may examine the facts.
Please.
350 acres of land was specifically earmarked for upkeep.
That is the order.
That has been a,
my lord. That is against the record.
Page 41.
They have produced the original notification itself as at page 41. my lord.
The de-reservation of the
Annexure
forest
D,
land
my
order
lord.
is at page 40.
Annexure D. I read, my lord. Annexure
Page
D.
41.
In exercise of powers conferred by
Page 41, my lords.
my lord, annexure D.
Typed copy. 29th January 1962.
51.
Sources notification
45.
dated 29 January 1960.
That's the
my lord. In
deforestation.
exercise of the powers conferred by subsection 1 of section 30 of the Mysore Forest Act 1990, as enforced in the Mysore area, Government of Mysore hereby directs that the area specified in the schedule below, which forms part of Ragelli Forest constituted by government notification so dated 3rd February 19, shall cease to be a portion with said state forest with effect from the date of this notification schedule. Nowhere it mentions, my lord, it is for the purpose of Hakki Pakki or Irudiga.
my lord,
Subsequently, at the instance of the local
But
political.
then the beneficiaries are given out of.
My lords.
Yes,
my
ma'am.
lord.
It is allotted to different communities, my lord, but they don't want me to be allotted.
My
They
lord-
want it exclusively for
my
me.
lord, what, if my lord sees that
Why the
page
cost
that
of
is,
me, my lord? We are only 23 people who are nomadics. We are settled there for.
But then these Pakki people is this allotted in which year?
my lord, now.
They are
My lord,
now
if I may
under
just
this
submit,
memo.
my lord, if I may
lords.
just clarify,
After the
2016.
Now.
my lord, if I may just clarify certain aspects.
They are agricultural land
It's
Yes,
agricultural.
or for residential purpose.
So, now
Agricultural land, my
it has
lord.
come in
Agricultural
It's
activity.
agricultural land. My lord may see page 44, if my lord sees page 44, which my lord's is at.
For memo, 228 acres has been allotted to them. Remaining
Now, lords,
land available, it is clarified, our that will be.
And still some land is available, my lord. After satisfying their claims and after allotment.
No land is available, sir.
KT order.
No land is available.
Lords,
We've
once,
given you 2 acres, be
Your
satisfied with
lordships,
that.
my lords, kindly come to the KT order also at page 24, my lords. That will clarify the entire issue. Page 24, my lords. Paragraph 9 of the KT order, my lords.
appellate tribunal's order. Paragraph 9, may I read? Learned counsel for the appellant submits that the respondent after lapse of 40 years are trying to misread and misrepresent the contents of the notification dated 29/1/1962. By this notification, the government denotified certain lands from forest area, and he further submitted that there is no stipulation in the said notification that the said land is to be granted only to Hakki-Pikki or Iruligas. He further submitted that Respondent 192 in their impugned order stated that as per the directions of the government dated 23/9/2002, the said land is only to be allotted to Hakki-Pikki and Iruligas, but there is no such direction issued by the government. The learned counsel for the appellant submitted that government has already granted lands to respondents number 3 to 8 in the same area, and government has already granted the land to other persons who do not belong to Hakki-Pikki and Iruligas. Appellants belongs to depressed community who are unauthorized cultivation of the disputed land for more than 40 years.
In fact,
Para
this was-
11, my lords.
This was heard, and what was expressed was that for those who are not granted the land, marriage individual grievance.
Now, my lords,
Please, my lord.
they
Lord
have
had said, indicated, my lords, that those who have not been granted lands, individually they can pursue the matter. That may be done, and insofar as this petition is concerned, my lord had also indicated that it may be delinked and it may be sent back to the
But the
learned single
question, my
judge, my
lords,
lord.
with
That may
regard to
be
whether
done.
the land deforestation order of 1962 is reserved only for the Hakki-Pikki or for anybody who is in cultivation can be regularized, the question may have to be decided.
Other than 1097, which are the matter? 145733 and 13081.
Yes, my lord.
Two.
Please.
So two may be disposed of on the ground.
The other two can
Please,
be
both of
disposed
them may
of.
be
But,
disposed, my lord.
but the question with regard to whether the entire land is reserved for them or the other persons who have been granted will remain.
Please write down. We'll
That
say-
can be
We'll
clarified.
say this one, the subject matter controversy in writ petition number 1097/08 deserves to be dealt with by learned single judge in view of the disposal of the other two public interest petitions. It is clarified that while dealing with writ petition 1097 of 2008,
2008.
2008.
all the, in dealing with, in dealing so and so, all the aspects of merits for both these sides shall be open
Yes,
to be raised and agitated before learned single.
please.
In accordance with law.
Obliged.
This much will go.
Yes,
and-
yes, ma'am.
Great for
First
Linked.
And this will go to learned single judge.
Please.
Very
my lords.
well.
Please, grateful.
So we'll pass the order.
Please.
My lord, each, my lord, person has been granted 2 acres, my lord. And 2 acres in Bangalore today, my lord, a person becomes a crorepati. Even with that, they are not satisfied.
Who has granted this?
No, the beneficiaries,
2 acres.
2 acres each, my lord. I've got it done in 2023.
My lord, those grant certificates, in fact, I have placed on record. as
They are nomadic. In the heart of the city.
And the
And again, they are niggling, haggling here before my lords.
Grateful, my lord.
Give your appearance, take the appearance of everybody in each matter.
Please, grateful.
All appearance may be given so that it can be properly
Please, my lord. Most grateful.
Number 12.
Lord, I appeal for the
Union.
petitioner in this
But
matter.
in this case, my lords, on the last date of hearing, we had placed on record the meeting proceedings, my lords. And my lords had directed us to place on record the further developments after the meeting. My lords, I have received the action taken report. We'll make a compilation and place it on record. Request a short accommodation. Only today morning I received it.
Lord, may I just make one submission, my lord? If my lord permits. This is the matter regarding manual scavenging. And they may place the action taken report and further steps on record. Last week, my lord, one incident has taken place very close to Bangalore, where two workers have entered a sewage treatment plant and have died because of the toxic gases that have emanated from there. If my lord permits, I'll file a memo in this regard. An FIR has also been registered under the Manual Scavenging Act. Our only request is this. What has happened over the last 3 years, my lord, most of the incidents where workers are dying are happening in sewage treatment plants, STPs, which actually are very unregulated, my lord. The Pollution Control Board has passed an order directing that all residential units and commercial units must establish sewage treatment plants. But in respect of worker safety and ensuring that safety equipments are provided to workers and their health and lives are protected, no steps have been taken at all. There is no regulation. We have in fact filed an application in which we have sought for a specific prayer seeking that some regulations may be developed by the state in respect of sewage treatment plants that are concerned. My lord, my only request is that let the state look into this issue, given the fact that over the last 3 years, the majority of the deaths that have taken place are in these sewage treatment plants. If they could frame certain specific guidelines that would look into ensuring workers' safety in sewage treatment plants, that would go a long way in ensuring that these incidents don't take place.
Final disposal will consider.
Please, my lord, if they may.
But then we are keeping on which date?
My lords, I request 2 weeks at least, my lords.
29th of November.
First week of December, my lords.
Week of December. 3rd December.
Grateful.
Grateful, ma'am.
Green bench matter, seal number 13. To Govindraj K. Joisa. Seal number 13.
Case. I am for the petitioner in this case, my lord.
You're for petitioner.
In this case, my lord, I filed seeking mandamus. Consider the representation, my lord. That, my lord, I am the traditional way of extracting sand, my lord, petitioner. That in the non-CRZ zone, my lord, I am working with the tenderers, my lord, licensed tenderers. So now I filed an application to issue permit to me to participate in the tender, my lord.
So you want to consider your representation?
My lord.
That we can.
My lord, but the second half of the prayer, my lord, an issue notice, and I'm sorry, an issue license, that cannot be.
No, that will not grant.
Yeah, very well.
License in the sense of permission, my lord. That enable me to participate in the tender. I fulfilled the conditions, my lord, that which imposed by them. Annexure B and C is the identity card which issued by the for the traditional sand extracting, my lord.
by filing this petition under Article 226 of the Constitution, the petitioner wants Respondent 3, that's the Deputy Commissioner, Udupi District, and Respondent 3, and Respondent 4, the Senior Geologist, Udupi District, to consider petitioner's apostrophes representation dated 11/12/2023 and 7/3/2024, and further to issue license to the petitioner for extraction of sand block, traditionally public manually, in the non-coastal regulation zone, into CRZ bracket or area. The grievance of the petitioner is that the case of the petitioner is that that it is engaged in the extraction of the sand. And worked for several years under the licensed tenders, and that his name is registered under the Department of Karnataka Building and Other Construction Workers Welfare Board, into bracket KBOC, not necessary, Welfare Board. It is the say of the petitioner that it has filed a representation before Respondent 4 for obtaining license to extract. Respondent 4, that's the Senior Geologist of DB District. Senior Geologist Senior Geologist Manipal, Udupi District, for license to extract the sand by manual public traditional method. Manual, best traditional method. It is the grievance that the state request is not being looked into, on account of which the petitioner is not able to participate in the tender procurement process. It is the grievance that the request of the petitioner to consider such application for grant of license has fallen, has not been responded to. Paragraph, looking to the case of the grievance of the petitioner. This petition could be disposed of by directing Respondent 3 and 4 to consider the representation of petitioner dated 11/12/2023 and 7/3/2024. In accordance with law and on merits. Paragraph, learned advocate for the petitioner, Mr. So-and-so, would submit that time frame may be fixed for rendering decision on the representation. Also, learned additional government advocates, Srimati Nilofer Akbar, who appears on service of copy of the petition in advance, submitted that representation of the petitioner will be considered strictly in accordance with law and on merits. Full stop. In the aforesaid view, this petition is disposed of by granting limited observations in favor of the petitioner, that the representation of petitioners will be considered by the competent authority of the respondents, and a decision on merits will be rendered within 10 weeks from today.
Obliged.
The same shall be communicated to the petitioner. No
Much
further
obliged.
relief could be granted. The petition is accordingly disposed.
Yes. Writ appeals, seal number
Please.
14, Mr. K.B. Naveen Kumar.
I appear for the council for. The reference order is quashed by one single judge. Appellants are workmen or the first respondent who obtained not voluntary retirement in the not COVID pandemic period. Not. August 2020 scheme was introduced. On the same day, 26/8/2020, not voluntary retirement, settlement, everything by pressure. Then they raised a dispute not before the Deputy Commissioner of Labor. On the government not refer the dispute to the not Labor Tribunal not. My lord will find the reference not page 182. (183) is the English translation. The reference is not whether they are entitled the revised not compensation under the settlement. It's a reference. But it is the domain of the Labor Tribunal whether not they can be compensated, they cannot be compensated. Is in the domain of Labor Tribunal. Not making a reference is a rule. Rejecting the reference is the exception. But here is a case, Lord. According to them, Lord, they have not been given settlement as per the Lord scheme. The learned judge, Lord, relied upon a decision, Lord, 2003 Supreme Court. Lord, absolutely facts are entirely different. In A.K. Bindal case, Lord, para 19, says, Lord, they have opted voluntary retirement, taken benefit, therefore no dispute. Under section 2S, not the A.K. Bindal case, Lord, principle is entirely on different broad context, Lord, it has been rendered.
Our learned advocate, Mr. So-and-so, for the appellant. Appeal is admitted. It shall be posted for final hearing on 6th December.
Yes. Notice may be issued to the respondent.
Number 1.
So admission shall go to the respondents.
Yes.
Seal number 15, Mr. Som Sundar Rao. Mr. Som Sundar Rao.
It is not there than 4th December. Delay is the delay for keep back.
Seal number 16, Mr. Cyril Prasad.
Delay.
I would ask for short accommodation.
Why?
So senior is unwell.
Delay will issue notice. There is a delay of 345 days, 397. Heard learned advocate so-and-so for the applicant. Notice returnable on. Because no order except notice can be given at this stage. 29th November.
Seal number 17, Mr. Madhukar M. Deshpande.
17/2, my lord, I am appearing, I have got some office object has to be complied.
Pardon?
As far as the second matter, my lord, 915, lords, writ appeal 915. But I am appearing for the petition, I mean, appellants in this case, what's office object has to be complied. I have to comply. Same order, my lords.
So you on time?
Please, my lord, sir.
Hold it. 3 weeks time is granted to comply with the official. Both together. Any urgency? There is no urgency. Let it be listed on 4th of December.
Fourth issue.
Both the matters may be listed on 4th.
Please.
16 and 17 and 721.
My matter, my lord, I have sought for a transposition of appellate number 2 as a respondent number 3. The reason is that, my lord, he is representing the
Company
and
plots.
he has filed an independent. I have filed appeal on behalf of the Union of India, that memo may be allowed, so that I can transpose, so that technical mistake can be rectified. I filed a memo to that effect.
So in writ appeal 920, first order, separate order will be passed. Or common order, but the order in writ appeal 920 or 24, stand over to 4th December, within which time the office of objection will be removed. The appeal may be listed with writ appeal number 924 of 2024. An order in 924, full stop, on the record of this appeal, from a figures memo dated 38/10/24, in which the appellant, Union of India, stated that appeal number 2 is a company in liquidation, which has filed writ appeal number 920 of 2024. Therefore, appeal number 2 is required to be transposed as
14 and
3, full stop.
14.
The memo filed above is treated as an application. The prayer for transposition is justified in the facts of the case. Full stop. Appellant number 2 shall be transposed as response 3, and the title of the appeal shall be accordingly amended. Normally, you are supposed to file application or not?
Since he filed an
Independent sub. Please.
No. Instead of memo, you any.
This number 18, MC Basuraj. Still number 18, MC Basuraj.
5th December.
Number 19, the Girish TR.
State in the matter, no?
Appellant's counsel. On the learned single bench, at the impugned order at page 18, dismisses my petition on the sole ground that it is a policy decision. I have impugned a notification of the government. The learned single bench dismisses my petition on the ground that it's a policy decision. But the problem is not, I may be forced to relocate by virtue of this communication impugned. I am not Mahila Supplementary Production Training Center.
What is the ground of challenge?
It's not the problem is not the no doubt it's a policy decision. My grievance is not that I may be forced to relocate my entire premises
Supposed to?
pursuant to this impugned notification, not which I challenged before the single.
But we have gone ahead with the, as per the Honorable High Court and Supreme Court's directions. May I request my lords to kindly permit me to read page 32 annexure A, my lords. We have the very first paragraph, my lords. Page 32 annexure A. This was the impugned order before the learned single judge, my lords. It starts as subject regarding revamping modernization of the MSPCs in compliance with the Honorable High Court and Supreme Court's order. The government has taken a policy decision to say that the centers have to be now revamped, and we have indicated as to how it has to be revamped in the very next page, my lords.
Why you are aggrieved?
I may be forced to relocate, my lord. That is my grievance. My grievance is that, my lord, by virtue of this communication, I may be forced to, my lord, relocate my entire premises.
I'm for the private group, my lords. After meeting with the government, I'm bearing the entire expense myself. I don't think anyone can be aggrieved. The state is not spending a paisa out of the entire thing. I have to bear the entire expense. The observation of relocation at this stage, my lord, that will not be the ground of challenge.
So and so for the appellant original petitioner from a learned advocate, Mr.
Banu Prakash, my lord.
Your senior advocate,
Additional Advocate General, my lord.
senior advocate, Mr. So and so. For respondent, so and so, and learned senior advocate, Mr.
Vikram.
For respondent, so and so. The present writ appeal is directed against judgment and order dated 30th September 24. In writ petition number 24967 of 2024. Thereby, the writ petition of the appellant, original petition came to be dismissed by learned single judge. The challenge in the writ petition paragraph goes to the communication dated 20th/7/24 issued by respondent 2, that's the Director, Department of Women and Child Development, whereby it was directed that the Mahila Supplementary Production Training Center, all first letters capital, shall be modernized and revamped for its operations in order to improve the quality of food provided to the beneficiaries of the Integrated Child Development Service Scheme. Learned single judge took view that learned single judge taking a view that the nature of the communication was purely in the policy domain, and it was a policy decision of the state based on financial considerations. The view taken could be said to be eminently legal and proper. Not only that, when the copy of order dated 20th/7/24, which was impugned before learned single judge, is seen, it could be noticed that the revamping and modernization of the Mahila Training Center concerned is pursuant to the orders passed by the Honorable High Court of Karnataka
And Supreme Court.
And affirmative.
also of the Supreme Court. In the any number is mentioned?
Yes, my lords. Page 32, my lords.
The writ petition
In
number,
writ-
my lord,
in
this
writ
on
petition number 3522
3522 of
2020,
22.
for my
and-
SLP number 18930/2022 and others, full stop. The change, the challenge to the order of learned single judge is entirely misconceived in law. The appeal is meritless, it is dismissed.
Grateful, my lords.
So ready in notice matters, still number 20.
Lord, appear
Yes,
for the
Ankit
appellant.
Reddy.
Appear for the appellant, my lords.
Response 4 and 5. And I have to file my counter because Lord,
20.
Appear for the appellant, my lord. I have no objection for granting an adjournment to appellant side.
suit ಎಲ್ಲ ಇದೆ ಅದು ಏನಿಲ್ಲ.
So dismissed, covered by.
Writ petition was, no, it's not covered, my lords. I have gone through the judgment which was made earlier. That has no application whatsoever. Facts are totally different. In the case of Lakshmama, my lords, in writ appeal number 1627 of 2023, the facts are totally different. Lord, an application for resumption and restoration was filed. It was granted, it was allowed in that case. Thereafter, my lord, by taking permission of the government under section 4,
Proceedings are closed in 81.
That my lord, there was no application, it's a suo proceeding, in which my lord, the grantee was not a party. I will make my submissions by physically appearing, my lord, since my late friend said he would seek an adjournment.
You are from Bangalore or outside?
Lord, I am for the appellant.
Bangalore.
Then kindly come and physically so that it is facilitated.
Yes, my lord.
Appreciate. Monday or Tuesday, whenever the council wants.
Yes. May I request, my lord, this may kindly be called of 2 weeks, my lord, I am suffering from dengue fever. I am suffering from dengue fever.
अच्छा, ऐसा है.
May I request, my lord, for 2 weeks?
Which date? 2 weeks you want?
Yes, my lord.
25th
Because I have
of
got
November.
severe pain in the joints.
Doesn't matter. Whichever date you suits you will give. 25th of November?
Yes, my lord.
Please. Commercial appeals, serial number 21. Number 21. Archis Chaudhary. Chaudhary.
Please. 26th November. 26th.
Serial number 22.
22 instructions to appear for the respondent. The arguing counsel has some difficulty today. Will accuse me have it sometime next week. Notice has not been issued yet.
Sure. For this time. They're not on period also.
These are the appeals. Appeals under section 30.
33.
Common order passed by the section 34.
So 37 appeals.
This is the 37 appeal filed before your lordship. Now, my lord, 8 is the date fixed for execution. They have been directed to take steps as against BBMP is concerned. Entire amount, my lord, as fixed by us, Lord, has been paid. However, the arbitrator, my lord, does not even take that into consideration as to what exactly is the amount what has been paid. Even that also, my lords may kindly see, may request your lordships to kindly turn to, Lord, page number 84 for a minute. This is the arbitrator's.
May I make this submission? On the 8th, my lord, we will not precipitate the matter.
We'll grant you time if need be. Yes.
Lord, page number 84.
Yes.
Point number C. This is the submission made to the arbitrator. So submits that an amount of 3.55 crores was credited to the account of the claimant after the filing of CMP, and therefore no receipt thereof is issued. Now, my lord, this also is not taken into consideration. May I request your lordships to kindly turn to page 95 now.
So receipt is not issued.
They admit that they have received amount from me. But however, learned arbitrator, my lord, does not take this into account. Learned arbitrator says, no document is produced to show that this amount is paid.
No, any form of acknowledgement is there.
Acknowledgement they have not given, but amount is credited to their account.
So any evidence is there to show that?
My lord, it is their statement. It is petitioner statement, that is respondent statement before the arbitrator.
This Umare is this
Yes, he is the counsel who appeared for the claimant before the arbitrator. This is their statement. And learned arbitrator, my lord, at page number 95 says that there is no document produced by us. Lord, this is a case where, my lord, they had sought for 27 crores insofar as under various heads, insofar as a tender, my lord, which was given to them in respect of various wards are concerned. Kindly see page 95 now. 7 lines from the bottom of that particular paragraph. Statement commencing from, no document is produced. Lordship gets
It is towards full and final settlement.
This was towards full and final. What had happened, my lord, is this.
Or
A representation was.
statement shows that only credited on the account. But
Please, no.
the statement at page 84
Yes,
mentions that it is credited.
it is credited to their account.
It doesn't say that full and final settlement.
My lord, I had said it is towards full and final settlement. However, my lord,
In any view, this 3 crores is paid accordingly.
it is paid. It should have been taken into whatever amount, my lord, learned arbitrated has had come into conclusion, come to a conclusion. My lord, that amount, this amount ought to have been given deduction. Even that also, my lord, is not taken into consideration. My lord, basically 27 crores, my lord, was the claim made against us under various heads. Learned arbitrator rejected most of the claims. And ultimately, my lord, learned arbitrator came to a conclusion that 3.54 crores is the only amount which I am supposed to pay. If the 3.5 were to be taken into consideration, I am liable to pay only 4 crores, 4 lakhs. This was paid by me on 28/2019.
So this is total covering the all cases.
Please, my lord.
These 3 crores cover all cases?
Yes.
All
it-
claims?
It was not paid in one lump.
No,
It
no.
was,
You said there are 13, how many?
12 petitions.
12 petitions.
Yes,
Different claims.
yes,
So this 3 crore will cover all the claims.
yes.
I need to take instructions. I'm only seeking a week's time. I understand 8th is the execution petition. We will not precipitate on the 8th. But I'll take, I don't have instructions. I'll take instructions, my lord. Not just may have it anytime next week, my lord. We'll argue it finally.
Only instruction is to be taken is whether you received the 3 crores or not.
No, we'll take, no, on the 8th, I'm making a submission. We will not precipitate the execution.
Let the statement be recorded, my lord.
So
because
I am
he
making a
just-
statement. We will take adjournment on the 8th.
No, he.
That is what we are.
In fact, I have prepared one statement as such. But what is the committee of BBMP has passed? And then what does the arbitrator has done it? When I tally both the things, my lord, approximately, my lord, it comes to 3 crores 54 lakhs is the total amount which I am liable to pay as per the arbitrator's award also. Now in that, I have already paid 3.5 crores.
I don't have the benefit of the papers, my lord. Is not fiscal kindly.
All these are the appeals under section 37 of the Arbitration and Conciliation Act. Arising from common
Page 23.
judgment in order. Dated 3rd August 2024, passed by learned 85th Additional City Civil and Sessions Judge, Bengal. In commercial, rejecting the commercial, dismissing the commercial application numbers, commercial arbitration petition numbers 106 of 2023 to 118 of 2023.
No, it should be till 17, my lord. 118 was filed by the respondent.
106 to 117 under section 30 of 2023, under section 34 of the Arbitration Act 1996. One of the major ground. It is a major ground on part of the appellant, Bharat Bengal Mahanagarpalika, canvassed by learned advocate, Mr. So and so appellant, that towards the different claims, covering the different, towards the coverage of different claims by the respondent claimant, a total amount of rupees 3 crores,
3.5.
3.5 crores paid. However, the said payment is not taken into account by the arbitrator. Learned advocate in this regard invited attention of the court to the submission made on behalf of the respondent by his learned advocate, figuring at page 84, which is part of the copy of the judgment and order of the award of the arbitrator. It was pointed out that the arbitrator has brushed aside the statement of the respondent himself acknowledging the payment, by observing that there is no documentary substantiation in that regard. Paragraph. In course of the consideration of the appeal, learned advocate Mr. So-and-so who appeared to the respondents prayed for time. Full stop. While praying for time, he made a statement that although the execution application is filed and the same is slated to be listed before the competent court on 8th of November, the respondent shall not press the said execution proceedings on the said day, and the same shall be adjourned. It shall be requested to be adjourned by making appropriate request to the executing court. Full stop. This statement is recorded. The respondent shall act accordingly. Next, as far as the aspect of payment of ₹3.5 crores by the appellant to the respondent is concerned, on the next date, the appellant shall produce on record the documentary proof about the payment of the said amount to the respondent. To be listed next on
The short date,
which date?
any.
13th November?
Please.
13th
Please.
November. All the matters, all matters will be 23
to 33.
23 to 33.
22 to 33.
22 to 33. Common order.
May I, my lord, may I receive a copy of the papers?
Looking to the prima facie compass of the controversy, to be listed at 2:30. So this is the only thing.
It appears.
Then all matters will go if you have received the amount.
Please. I'll have to take it.
Yes. Number 34, Mr. Anumat Reddy Ji.
Appearing for the appellant. Not the present appeal has been filed challenging the judgment and decree dated 9/9/2024. Now, the factual matter says the appellants of the National Highway Authority, the land of the respondents number 1 to 3 was acquired for the purpose of widening of the National Highway. And subsequently, a compensation was determined by the land acquisition officer to the extent, 2,913 rupees per cent. Not satisfied by the compensation determined by the land acquisition officer, the respondents filed an application under 3G5 before the arbitrator. And such award has been enhanced, by the arbitrator. The amount determined by the arbitrator has been enhanced to 1,75,032 rupees per cent. And the said award was challenged under 34. And the learned district court, the Honorable District Court confirmed the arbitral award, and the same has been challenged before your lordship. Please, if your lordships can see from at page number 49, 48, the arbitrator has taken into consideration the relevant two aspects question which has been taken into consideration, as to whether the second respondent has acquired the land and passed the compensation award by following the due procedures as under the National Highways Act, for which the arbitrator has answered in affirmative, though the arbitrator has answered in affirmative, subsequently in second point that whether the compensation fixed by the second respondent is just and reasonable, the arbitrator has answered in negative without giving a detailed reasoning, my lord, on basis of which we had filed a petition and challenged the same under 34. My lord, the arbitrator, special land acquisition officer had taken into consideration the provisions of 3G7A for the purpose of determination of compensation, read along with section 26 to 30 of the RFCT LARR. And the reason for the enhancement has been given as due to the severing of the land, my lord. Subsequently, also, a commercially converted order has been produced by the respondents before the arbitrator, my lord. However, the same was not produced before the special land acquisition officer, and the land acquisition officer has taken into consideration of the nature of the land as in the revenue records. That is the key. If your lordships, please, my lord.
Yes.
My lord, on these grounds, we have challenged the. I've also, as part of my appeal memo, my lord, I've reported two judgments rendered by the Honorable Supreme Court, wherein has talked about the patent illegality, my lord, if I may, my lord. Page number 15 of my appeal memo. Paragraph 27, my lord. Lord, Parrot 27. The Honorable Supreme Court in the case of Associate Builder was a DDA reported in 2015 3 SCC 49 has held in Para 34 as it is with this very important caveat that the two fundamental principles which form part of the fundamental policy of Indian law that the arbitrator must have judicial approach and that he must not act perversely.
Where you are reading?
Para 27, my lord. Page number 15 of my appeal.
Page?
15. In page 15, my lord, Para 20.
Referring some Supreme Court.
Please, my lord.
On the scope of section 30.
34, my lord, and the as to how it can be against the fundamental policy of Indian law and what is the patent illegality that has been determined.
The courts have said that even minor illegality will not be a ground.
My lord, but just a humble submission is when the arbitrator has considered that the special land acquisition officer has followed all the due procedures as with respect to the provisions of the National Highways Act and RFCT LRR Act, then enhancement of compensation has been made from 2,193 rupees per cent, my lord, to 1,27,000. And the nature of the land, as mentioned in the revenue records made available with the special land acquisition officer, the nature of the land is dry land, my lord. And the commercially converted order, the land for the commercial purpose, has been only produced before the arbitrator, my lord, and not with the special.
Arbitrator says that it was a converted land.
Please, my lord.
Land was converted.
Please, my lord. Land was converted.
So in that light, there is a enhancement.
Enhancement of compensation, my lord, but the arbitrator has enhanced without any particular inquiry, my lord, because the special land acquisition officer had also determined with respect to some other lands with respect to commercially converted lands, my lord. And also this particular document was never produced before the special land acquisition officer.
This 1 lakh enhancement is not a compensation determined by the officer as such. It is an enhancement in the award by the arbitrator. On the consideration that the land which was considered was agriculture, but at that relevant time it was already converted into non-agriculture.
Please, my lord. My lord, but this document was never produced before the special land acquisition officer. If such, my lord, under this provision of the national.
Where from this page 50 finding is recorded by the arbitrator?
My lord, such document was produced before the arbitrator, my lord, but it was not. It was not produced before the special land acquisition officer. Even so, my lord, the rate of the commercially converted land in the vicinity of that village is much lesser than as to what has been given by the arbitrator, my lord. My lord, my humble submission is there is a merit of the case.
1 lakh. Which judgment you are relying?
My lord, Associate Builders versus DDA reported in 2015, my lord. Subsequently, also the
Many,
The Sangyong Engineering and Construction Company Limited versus NHAI, my lord.
many judgments have come recently.
Please, my lord.
Recently, many judgments on the scope of section 34 and 37 is
Please, my lord. Please, my lord.
reported
Please, my lord.
by the bench headed by Justice Oak as he
Please, my lord. Wherein the,
find out.
please, my lord.
We'll see who appears. Nobody appears.
No, my lord, notice has not been issued. Let me-
How many respondent?
Respondent five respondents are there, my lord. Respondent number 1, 2, 3 are the land losers, my lord. The claimants were for the arbitrator. The respondent number 4 is the learned arbitrator, and the respondent 5 is the competent authority, the special land acquisition.
Notice returnable on 26th November.
Please, ma'am. Grateful.
To be listed at 2:30, looking to time of issue scope of the controversy.
Grateful.
Noticed in course of hearing.
Obliged.
Arbitration matters, MFA, seal number 35. To A.N. Krishnaswamy.
Sir, copy on the caveat. Lord, we had a talk today morning. It is a claim, an appeal filed by insurance company. A burglary policy was issued. There was no forceful entry even according to the claimants. The
Challenging what?
the amount assessed by surveyor is around 8 lakhs. But 30 lakhs is awarded. My learned friend who appeared for caveator was, my learned friend for caveator, he was making a submission that we can sit and check out the difference also. I said, if execution is not pressed, can have it. That surveyor, surveyor appointed by the insurance company, he is valued at 2,38,746. The arbitrator has proceeded to assess it at 32 lakhs. Police also had valued the
Notice.
stay candidate.
No. Where is the question of grant?
I will deposit 50% before.
Now, right now, no.
Could it be taken up in month of December, first week of
Earlier,
December, so that we can
Well,
decide?
December.
Lok
first,
Adalat
third,
also we can.
2nd December.
It could be referred to Lok Adalat also. It could be referred to Lok Adalat, we can.
Let the other side come, then
Others, I had a talk with him. My learned
then
friend
we'll
was-
refer ready. Come with the other side at 2:30. Keep it mentioned.
Complaints in contempt matters, seal number 36. Fellows, I am appearing for the complainants, ma'am. Fellows, the writ court, my lords, was pleased to pass an order, my lords, at Annexure A, directing the respondents, my lords, to pay the compensation towards the land acquisition of the complainant's land in accordance with law, my lords. That is, my lords, with regard to 155 square meters of land acquired, my lords, in within notification in 2021. May I draw my lord's attention to Annexure A, my lords? At page number 18 is the order, my lords. At page number 22, short issue involved in this writ petition is with regard to payment of compensation in respect of land measuring 155 square meters, which was required with a preliminary notification, which was acquired with a preliminary notification dated 26/8/2021, followed by final notification dated 2/11/2021. Now, the final order, my lords, at page number 23 is that, my lords, it has to be paid, my lords, within stipulated period in accordance with law. Now, my lords, in compliance of the same, my lords, the affidavit has been filed by the accused, my lords. May I draw, my lords? Wherein, my lords, the accused, my lords, have taken contradictory statements what they have made before the writ court, my lords. If at all, I may draw my lord's attention to the statement of objections, my lords, that they have filed before the writ court, my lords. May I draw my lord's attention to page number 221, my lords.
Your KIDB? I'm for the DMRC, accused number 3 and 4. We issued an endorsement, which is at page 57. So what we've stated in short is this. A submission was made before the learned single judge that the acquisition proceedings would be taken to their logical end and compensation package would be deposited. Now, on a resurvey, we found that instead of 155 square meters, 129.05 square meters is the land in respect to which we have to award compensation, of which admittedly 78 square meters was already paid. So that's not an issue. In respect to the balance 51.05 square meters, despite the fact that we've actually paid it to the wrong person, to show our bona fides, that money has already been deposited with to the KIDB, and they can withdraw it. 1 crore 36 lakhs has been deposited. They can't force our hand to acquire 155. In fact, pursuant to that, we've also written to the KIDB to denotify that land which was wrongly notified. Agreed by that, they'll have to challenge it.
Malos, the petitioner, Malos, is the owner of 2,771 square meters, Malos. Initially, they have issued a notification, Malos, for acquisition of 371 square meters of petitioner's land, Malos, in the name of petitioner.
Page 57 of my reply. Our reply was filed on 30th May 2024. A reply filed by accused number 3.
30th May. That's so
at page 57 is the endorsement.
correct.
And followed by, we've also annexed the letters we've written to the KIDB to take action to denotify that excess land, since it is not being utilized at all. Page 57 contains an exhaustive explanation as to why exactly 129.05 is the subject land. 78 has already been paid. Balance 51, 1 crore 36 has been deposited with the KIDB. And the last paragraph, we have told the petitioner also that he's at liberty to withdraw it.
But at the same time, Malos, if I may draw my lord's attention to page number 56, Malos, is the memo of calculation that they have filed.
Excess compensation of speed.
Yes, ma'am. That was 1 crore 36 was the balance amount which we've computed. In fact, that 1 crore 36 was actually paid to the wrong person. There's one, madam, I think Mrs. Bindu Raheja. So we've in fact written to the KIDB saying, even though we're taking time to recover that amount, since we've undertaken before this honorable court that we'll pay the amount, that 1 crore 36, even without recovering, we've paid to the petitioner.
Malos, that 133, Malos, is not in accordance with the guidelines, Malos. I'm also objecting to the memo of calculation. what they have
Let
filed.
them challenge that.
Challenge.
They're not,
Malos,
not
if at all I
agreed
may,
to the
if at all I may,
computation.
Malos, may kindly see, Malos, that page number 57 of their own statement of objection, my lords, wherein they have mentioned, my lords, the calculation of compensation. My lords, in that, my lords, they have not even included the interest component, my lords, whereas the writ court has directed them, my lords, to pay in accordance with law. When the writ court, my lords, has specifically said that it has to be paid in accordance with law, the interest component ought to have been included. So there is no non-compliance, my lords, on part of the accused. So, my lords, if at all I made to go for the writ court, my lords, again for that purpose, my lords, no purpose would be served. My land, my lords, was acquired in 2016. My lords, compensation was paid to somebody else. I gave several representation, my lords, the compensation was not released to me. In 2021, my lords, additional land was notified, my lords. Because of that additional notification, my lords, I couldn't utilize my land, my lords, for any purposes. Now they are saying, my lords, by mistake they have notified it and they will rectify it now.
So you deposited excess amount.
Yes, ma'am. We actually deposited that amount which was notified earlier.
But they have withdrawn also.
Yes, ma'am. Now they are at liberty to withdraw. It is with the KIDB now.
They have deposited 1 crore 36 lakhs. They have issued a notice to the complainant to come and receive the compensation. They have to submit
lords,
document, they have to receive
my lords, my respectful submission is, as per the writ court order, my lords, they have to pay for the acquisition as per the in accordance with law. When they say, my lords, in accordance with law, as per the provisions of fair compensation, my lords, interest component ought to have been included, my lords. If I may draw my lord's attention to the Supreme Court judgment, my lords, in 2024.
They are not
wherein,
subject matter of contempt.
my lords, only I am saying, my lords, that the compliance is not in terms of the order, my lords. My lords, when the court has specifically said, my lords, that compensation has to be paid in accordance with law, interest component ought to have been added, my lords, in the calculation sheet. Now, my lords, that they have not included. So they have to recalculate, my lords, and submit, my lords. Then, my lords, I can challenge it. Now, my lords, even assuming, my lords, without considering that they have done it, they have included, my lords, for the different land towards this acquisition, my lords. If at all I may draw my lord's attention to the notification, my lords, whatever they are relying.
Just will go through tomorrow, 2:30.
Please.
Make one. There number 48, Mala. Filed a wakalata, impa other side, 2 weeks time to file reply, Mala.
Take a date.
Plus, may I ask for Monday, my lords?
We'll forget it. Why?
Tomorrow,
Come today itself. After recess, 3 o'clock.
please. Please.
make a submission. Serial number 77. It is a PIL challenging the compulsory imposition of Kannada language on school students. There is a urgency, my lords. I filed an IA for early hearing. Past occasions it's not reached. My request is maybe fixed for a date convenient to the court at 2:30 PM that the matter is heard.
What is the imposition of?
Kannada language compulsorily on school students from grade 1 to grade 10 in CBSE and ICSE subjects. All this while it was not a compulsory language. Now it has been imposed as a compulsory language on as second language. It is affecting a lot of students and their academic performance is being affected because those who never spoke Kannada. Academic performance is being affected, man. And there's a similar stay granted for students of degree students by this honorable court.
We'll see, let us see what happens.
After receiving the endorsement from the registrar of the court, we came to know that the respondent number 4 was taken. I will find necessary application to bring the allotment for the
Time, 13th December.
Serial number 44, my lord, appearing for R2, the tree cutting matter where AG had appeared, my lord. In this, the petitioner had informed that the matter had been adjourned to 25/11/2024. It is the emergency matter, my lord, requesting the court to see the matter be posted next week, my lord.
Which one?
Serial number 44, my lord.
We are for the petitioner in this, your lordship.
The tree matter.
Yes, ma'am.
Why early?
There's a loss of government fund, my lord, every day.
What government?
The metro construction where there is loss.
Not possible. Not possible. Yes.
Serial number 36.
Where is the council? Tomorrow at 2.
Tomorrow at 2:30, I have some difficulty. My colleague will be there once.
Day after tomorrow.
Yeah, not day after tomorrow.
Tomorrow.
Passover matters, serial number 15.
15.
R. Som Sundar. 15.
15. Nobody was present on behalf of the appellant in the first session as well as in the second round. Post the lunch session. In the larger interest of justice, instead of dismissing the appeal for want of prosecution, send over to December 16.
Serial number 35. Sri A. N. Krishna Swami.
Name on. Date not 16, but here 11th December.
So 230 matters, serial number 113. Sharon Desai, 14%.
My lord, I already
Good. What is this notification? What is this notification? Why you want to withdraw?
My lord, I already filed my first PIL at Gulbarga bench. Since your lordship has issued a notification on August 1st, that address my prayer, my lord, because this PIL doesn't hold good anymore.
By party in person. It was stated by learned party in petitioner party in person. With reference to the memo dated 1/6/23, filed on the record of the proceedings, that in view of the notification dated 1/8/24 issued by the High Court, and further in view that PIL is filed.
Yes, my lord, I filed on 23rd October, my lord. The first PIL at Gulbarga bench.
Filed at Dharwad,
Gulbarga, Kalburgi bench, my lord.
filed at Kalburgi bench, the present petition is not prosecuted.
With a great difficulty, my lord, because they were not accepting the PIL.
That this petition is accordingly developmental because of filing of the similar petition before the another bench.
No, not my lord. This PIL is regarding illegal buildings constructed in Gulbarga, Kalburgi limit, my lord.
Anything. Learned party in person appears and invites attention of the court to memo dated 1/6/2023. Paragraph. The memo reads as under. For the memo. In view of above, the petition is not pressed and is permitted to be withdrawn as infructuous, as stated by party in person in the memo.
Much obliged, my lord.
114, PN Nanja Reddy. We have filed the complaints affidavit, my lord. On 23rd October 2024, my lord.
Yes.
On 23rd October 2024.
Nobody is
complaints
there. Why should we? 16th December.
Number 115, Mr. Avinash Gowda, GS.
Issued two endorsements in both these cases.
Copy, my lords, I undertake to file wakalat for respondent number 4. And I filed a wakalat today in 116, my lords. I am respondent number 4 in both the matters.
Lordship said